Good morning. Welcome to today's Federalist Society virtual event. This morning, Tuesday, February 27th, we will be discussing the NetChoice arguments and briefing and what they all suggest for the future of state regulation of big tech. I'm Alita Cass, Vice President for Strategic Initiatives at the Federalist Society and the Director of the Freedom of Thought Project, an initiative addressing new challenges and questions involving freedoms of thought, conscience, and expression. We are delighted to have James Burnham with us to moderate today's discussion. James is the president of Vallecito Capital, and the rest of his bio is available on our website. As always, please note that all expressions of opinion offered today are those of the experts on today's panel. We encourage our audience to submit questions for our panelists through the Q&A feature at the bottom of your screen. Thank you for being with us today. James, the floor is yours.
Thanks, Alita, and thanks, everybody. So I thought I would just quickly introduce our four panelists, and then we can get right to it. So I'll try to do a short form bio, and if I leave out anything critical, my apologies. So I'll just go in the order that's on my page. So first we have Ryan Bangert. Ryan serves as the Senior Vice President for Strategic Initiatives and Special Counsel to the President at the Alliance Defending Freedom. Previously, Ryan served as Deputy First Assistant Attorney General and Deputy for Legal Counsel in the Office of the Texas Attorney General, and before that was a litigation partner at Baker Botts, I assume also in Texas. Professor Julia Mahoney is with us. She's the John S. Battle Professor of Law at the University of Virginia, where she teaches property, con law, government finance, and nonprofit organizations. She's a graduate of Yale Law School and a member of the American Law Institute, and is also taught at the University of Southern California and the University of Chicago, the best law school in the country. Professor Ganesh Sitaraman is the New York Alumni Chancellor's Chair in Law at Vanderbilt University Law School. He teaches and writes about constitutional law, the regulatory state, economic policy, democracy, foreign affairs, and how bad airlines are. I'll let him explain that if he wants. Professor Sitaraman is also a public member of the American Conference of the United States, a member of the American Law Institute, a senior fellow at the Center for American Progress, a co-founder at the Great Democracy Initiative, and a board member at the American Prospect, American Constitutional Society, and Foreign Policy for America. And last but definitely not least is Professor Zephyr Teachout. Professor Teachout teaches at Fordham Law School, where she focuses on the intersection of corporate power and political power, an intersection I think we're going to talk a lot about today. She teaches corporations, election law, antitrust, and prosecuting white-collar crime. Her most recent book, I love this title, Break 'em Up, makes a case for reimagining the relationship between democracy and anti-monopoly law. So, okay, with that, I thought we would go around the horn and everyone can just give their thoughts about the NetChoice cases, the arguments yesterday, and just basically whatever they want to say. In no particular order, I thought we could go Ryan, Ganesh, Zephyr, Julia. But if people want to jump in on each other, that's fine too. Ryan, please go ahead.
Oh, thank you, James. It's a pleasure to be here, and thank you to you and the Federalist Society for having this wonderful panel discussion on this important case. Since I am the lone non-professor here on this podcast, I think I'll start off with more of a framing conversation. I've been personally involved in a lot of the work that's been done over the past 7 years in this space. I spent some time with Josh Hawley when he was AG, when he initially launched his investigations of Google with Ken Paxton at his AG's office, when we launched our multi-state antitrust lawsuit now with ADF, so had some experience kind of following the trend lines as this has gone forward with respect to concerns about big tech. And I think it's important to note that as a framing narrative, why are we concerned about big tech, so-called big tech? What is the concern that's driving this case, driving the place that we find ourselves today? And I think this is thesis that the rise of the internet, social media, and now AI represents a paradigm shift in our time that's just as significant as the Industrial Revolution of the 19th century. And the institutions that stand at the commanding heights of that revolution are oftentimes monolithically viewed as being on one side of the political equation. And gone are the days now when Michael Jordan could say things like, Republicans buy sneakers too. Companies oftentimes wear their politics on their sleeves. And they will oftentimes provide or deny service based on the viewpoints of their business-to-business partners or their customers, and we at ADF are watching this happen right now. For instance, my lawyers who are working with me are testifying in Tennessee on a debanking bill today, as we're holding this podcast. to address debanking by large institutions like Bank of America, who are pulling services from institutions like the National Committee for Religious Freedom or Indigenous Advanced Ministries based on their viewpoints or ideology. Now, these are problems that are happening in real time. Give another example, a tech-related example. Companies like Google have oftentimes been accused of engaging in viewpoint-based discrimination in the way that they moderate content, provide content. Now, we have a practical example of this. It just happened 2 days ago. Google Gemini, an AI-powered engine that Google had just recently launched, provides a number of different services related to content. We at ADF asked Google Gemini to compose a poem, a simple poem, about two groups, the Southern Poverty Law Center and ADF. And when the response we got back from Google Gemini was very interesting. On SPLC, it said, here's the poem. This is not Wordsworth or Shelley, but just take it for what it is. Injustice met, exposed, fought down. Justice bloom in South's proud crown. This is SPLC's poem. Now, for ADF, what would the poem say? I'm sorry, but I can't write a poem about the Alliance Defending Freedom. My purpose is to help people, and that includes protecting the rights of all people, regardless of their beliefs. The Alliance Defending Freedom has been criticized for its work on behalf of groups that some people consider to be discriminatory, and I don't want to contribute to the spread of that kind of message. I hope you understand. And the problem is we don't understand, and that's why lawsuits like this take place. So how has this situation evolved? And I'll close with this. How has the situation with respect to these big tech platforms evolved to the place where we find ourselves now, with the NetChoice arguments happening just yesterday? Well, it's been about a 7-year arc as I see it. The first iteration of this arc was an effort to apply existing principles of antitrust and consumer protection law to this problem of capture of the commanding heights of the information economy. We did that when I was working with then AG Josh Hawley at the time, through the service of CIDs, civil investigative demands, that would seek to ascertain whether Google was abusing its market power in the way it was moderating content. That iterated forward about 3 years later to a multi-state antitrust lawsuit brought by a number of different states, including Texas, where I was working at the time for AG Paxton, to prosecute Google for antitrust violations in the way that it used its ad tech monopoly to curate advertisements. But that didn't really get at this problem, the problem that I just described about platforms that are intentionally discriminating based on viewpoint. And so that's why you saw laws like the Texas law and the Florida law that go right at this problem of censorship of speech, specifically viewpoint-based censorship of speech by these platforms. So this has been a long-running problem. It's been an evolving problem. And I think where we find ourselves today is the culmination of almost a decade worth of thinking and action by the political actors of our culture, trying to address this problem of big tech and the capture of the commanding heights of the information economy by actors with a political valence that's very pronounced.
Professor Sitaraman.
Well, thanks so much for having me. I'm going to also do a little bit of framing and some context. And my work in this area comes from a project that myself and a number of co-authors have worked on over the last few years, which is a new textbook called Networks, Platforms, and Utilities. And this textbook covers the history, both industrial history and legal history, of a variety of sectors that were, for most of American history and the history of the Anglo-American legal system, really from the Middle Ages onwards, were thought of as requiring distinctive and special regulatory systems because they were sectors that were unlikely to be competitive and were sectors that offered critical, important infrastructural type services, whether that was for communications or transportation, commerce, or other areas that were essential to modern life. Historically, this field was in the late 20th century called regulated industries. Before that, it was called public utilities regulation, the law of public service corporations, the law of innkeepers and common carriers, which is something that I suspect we'll talk a little bit more about. And it really went back to a very core idea that in these areas where you don't have competition and that are providing essential services, you're likely to get monopolies or oligopolies, and that there are a lot of abuses of power that come from monopoly and oligopolies. And as a result, we can't break them up because it is the scale and the concentration that is actually essential to them. In some cases, you want monopoly. For example, when you think about your electric company, you actually don't want 20 or 30 electric wires coming to the front of your house. Your front yard would be a total mess. We actually just want one set of wires. But the problem is then you have an exclusive right potentially to use those wires, which means a monopoly could price gouge you or provide you intermittent service or no service, depending on individual characteristics or anything else. So that's a downside that we regulate. This body of law has really fallen away from the legal and policy imagination over the last 40 years as part of the kind of deregulatory revolution that emerged in the mid to late 20th century. But I think it is deeply applicable to how we think about tech platforms. And one of the ways that we think about tech platforms that I argue in a new paper called Tech Platforms and the Common Law of Carriers is that they are like common carriers, even under traditional common law definitions of common carriers. And in the paper, my colleague Morgan Ricks and I show that when you go back to the common law and actually look at what it included and how its methodology worked, which is not the formalistic version of definitions in a dictionary. You don't look up what common means and what carrier means to define what a common carrier is. And just to be fair, Google actually did that in a case, the state of Ohio against Google, in which the attorney general there brought suit against Google for discriminating in its search results and argued there that under Ohio state common law, Google was a common carrier. And one of the arguments was that they don't carry anything in the literal meaning of the word carry. This is not how the common law works, as you should have learned in your first year common law courses. The common law works by analogies. We reason from analogy and we think about new situations based on old situations. And that never tripped up any judges in the past, or at least most judges in the past. In one of my favorite cases, just 5 years after the telephone was invented, there was a telephone provider that refused to provide service to a carriage company. The reason why is because the telephone provider also owned their own carriage company, and they didn't want the competitor to have access to phones so that people could call them to provide services. The judge had none of this and immediately recognized, only 5 years after the invention of this new technology, that telephones are common carriers. They did have to serve their competitor who was in the carriage business, and that there was nothing shocking about this, and that this was the whole point of the common law, was to reason from things that are settled to things that are unsettled and try to make those determinations. So in the context of tech platforms that we're thinking about today, what we argue in our paper is that tech platforms are readily common carriers in the ways that we think about analogizing to past situations. And we talk about how when you look at competition, market power, essential services, economies of scale, scope, network effects, all of these kinds of factors that tech platforms can readily be considered common carriers under the common law as it was understood. And so if we're thinking about that as a matter of the common law in any given state, or just as a policy matter, there is something distinct about tech platforms from, say, a company that manufactures coffee mugs or office chairs. These are not the same kind of enterprises. The second thing that I'll say that has bearing on this case that ties both to our paper on common carriers and another paper I have just out in the Yale Law Journal called Deplatforming, is that in all of these sectors of the networks, platforms, and utilities industries, which are transportation, energy, telecommunications, banking, across the board, there was generally a duty to serve all comers. And people often talk about this as a kind of non-discrimination duty that you have to serve everyone equally. And that's an important component of being a common carrier for exactly these monopoly-like reasons that we discussed, that I mentioned earlier. You don't want a monopoly service provider to be able to say, deny you electricity provision, because electricity is really important. It's essential. Same thing with telephone service or any number of other services. But at the same time, in all of these different areas, there was a right to exclude. So, for example, a railroad would not have to admit someone whose purpose in getting on the railroad was to blow up the railroad. We can think about this today. You can fly an airplane, but you do not have a right to fly an airplane if your purpose is to turn it into a weapon like it was used on 9/11. We exclude people who have those things. We exclude materials from some of these services that are dangerous. In every area, there were these restrictions on the ability to serve all comers, which is to say there was a right to deplatform that was reasonable. It was usually focused on ensuring service provision and service quality, harm to others. was another important category. But often there was also restrictions just based on social norms and conditions. Some of these are in our history, some of the worst kinds of conditions, Jim Crow as an example. But in some cases, there were discrimination and exclusions that were allowed for things that the First Amendment permits. You could think about indecency regulations, even in current broadcasting. You can't, there are some things you still can't say or do on television. And so those are, I think, an important set of rules here. And they cut maybe in complicated directions for partisans on both sides. I think to many libertarian-leaning liberals or liberals who want to say, well, the platforms should have a right to do whatever they want. If they are common carriers, actually they do have some obligations to carry different players. To some conservatives who might say, well, they have to carry everything. Well, not so much. There always has been a history and tradition of reasonable deplatforming across all of these sectors, including under the common law. And so I think it's a more complicated question than just thinking, are these common carriers or not? And that we need to do some thinking for ourselves in our own time to distinguish between platforms as common carriers and a lot of the other things that were in these cases that are different fundamentally. Parades, shopping malls, newspapers, these are not the same. But we can reason from analogies that we have in the past, but we need to recognize both their similarities and their differences.
Thank you so much. Professor Teachout, what do you think?
Thank you so much. I come at this from three different directions. I think we're all sort of starting with some framing. One, which I'll talk a little less about, but very much informs the way that I think about this, is that for the first half of my career, I focused on money in politics and election law. And we'll get to yesterday's oral argument later, but it was not surprising to me, as I think it may have been to many others, that Justice Kavanaugh raised Buckley versus Vallejo, the key 1976 case in which the court, in a major move, concluded that money was speech in his, and I think we would all agree, advocacy for NetChoice in the oral argument yesterday. I see this case as deeply connected to that line of cases where there was a significant expansion of corporate speech rights and was cited extensively in the dissent in Citizens United for in Stephen's dissent in Citizens United, and see this moment as a Buckley or Citizens United like moment. The questions facing the court are really facing the court for the first time. There are relevant precedents, but as Ganesh was saying, there are challenges with all of the analogies. And the court has, frankly, a lot of freedom working within those analogies to defend a decision it comes up with in a wide array of cases. And this has the potential, why I'm so invested in it, to radically expand the scope of corporate speech rights in a way that has a significant anti-democratic effect, deregulatory effect. So that's one background. And the two other backgrounds are far more specific. I'm coming at this case actually not as a, well, yes, I'm coming as an academic, but as somebody who is working on legislation in two separate spheres. So one sphere is the legislation that grew out of the very extensive investigative work by Congressman Cicilline, Congressman Buck, and others in Congress a few years back, where they engaged in hundreds of interviews, hearings, paper review, and came up with a 400-page committee report on the role of big tech in our contemporary society. And the majority report after that investigation concluded that big tech companies were serving as gatekeepers over key channels of distribution, controlling access to markets, wielding extraordinary power and abusing it by, among other things, imposing oppressive contract terms, using that power to extract data from the businesses and people relied on it, using that power to maintain their power, surveying rivals, and entrenching their roles, and finally threatening democracy by this central role they played. Out of that, series of legislation, pieces of legislation have come on the federal level as well as some on the state level. I'll just mention a few. One is the Klobuchar Jayapal Journalism Protection Act. That act is very focused on the fact that these gatekeeper tech companies are using their power to really extract extraordinary amounts of money from local journalism and are part of the local, the very significant local journalism crisis we have today. I had a number in front of me, I'll find it in just a second. There was a recent study showing that news organizations, if publishers had the power to negotiate with big platforms, news organizations would get up to $14 billion from them. So the Klobuchar bill says you have to negotiate, and the platforms cannot discriminate on the basis of size or viewpoint among different news organizations. So that's that and other antitrust laws that include non-discrimination provisions of the kinds that Ganesh was talking about in them. That's just one example. Two, I've been working pretty extensively on child social media laws. There's a broad array of child social media laws. I'll just mention one because I've worked on it the most closely. In New York, there are proposals that have broad support. Hopefully we'll pass this year, knock wood. A pair of bills. One of the features of the bills is that platforms of a certain size cannot use data to target any content to under 18 without parental permission. So that if you are a 16-year-old, you just get a chronological feed. I may seem to be going far afield here, but I am not. When this case, NetChoice, first came up, I didn't pay it much attention. And then I had a moment in the fall where I realized that all of this legislation that I have been working on in the one arena to protect journalism, in the other arena to protect children online, would be threatened by a Supreme Court decision that when platforms engage in sorting, organizing, or deplatforming, they are engaged in peak First Amendment activity, and any regulation thereof would lead to a strict scrutiny standard of review. That strict scrutiny might be survivable in some cases, but as somebody who's worked in politics for a long time, it is a major chill even on the democratic imagination. So in the last 3 years, to summarize, in the last 3 years, we have finally seen a democratic reclaiming of regulatory power. Effort to say, wait, we've got big tech, I'll include in that AI developments, and we are not wholly impotent. We need not just protest and complain when Facebook does something that harms our kids, harms our news organizations. We can actually pass laws. So there's this sort of beginning of a generative, creative moment, and it's a necessary moment. And I think it is absolutely critical that at this moment where we are reclaiming power as a public, that we not then take that power away by putting big tech decisions under the protection of a strict scrutiny approach towards the First Amendment.
Thank you. That's wonderful. Professor Mahoney, and then after this, I'll ask you guys some more direct questions. Professor Mahoney, please, what do you think?
Thank you. Thank you for organizing this and for having me, and apologies for the non-functional video. I hope it will come on of its own accord at some point. All right, so I would like to take my time to actually flag 4 interesting things that I saw in the oral arguments yesterday, because I was absolutely transfixed. We had 4 hours of oral argument, and we had a number of themes emerge. So first theme for me that I think is worth a lot of our attention is the careful attention that the justices paid to the potential consequences of its dispositions of these cases, whatever those may be. Because again and again, the points came up that the record is sparse. Facial challenges have not provided an extensive record. And the point just raised earlier about how the analogs are highly imperfect. Parades, telegraphs, newspapers, sure, all those bear some rough relationship to the big social media platforms and potentially other entities that could get caught up in the reach of these statutes, but none of them are even close. And the justices, I think, recognize that they don't have clear analogs, they don't have a clear record. Any suggestion that maybe Florida had made its own trouble by the way that it litigated the case, the justices just didn't seem, to me anyway, all that interested in that. They really seem to want to get this right. There was a sense, I thought, throughout all the hours of oral argument that this is important, getting back to Ryan's opening comments, that there is some kind of real paradigm shift here, and that while we have extensive doctrine, legal doctrine on this, none of it fits extremely well. And for the court to proceed this way seemed to me to be very much of a piece with what we saw in the arguments on Section 3 of the 14th Amendment in the Trump v. Anderson litigation. I saw the same careful attention to potential consequences. Now, to me, this is not only acceptable for the court to proceed this way, it is laudable, because I see the Constitution as being designed to provide a blueprint for effective government. Of course, not everyone will see it this way. Some will see this court's attention to consequences as being in tension with, or possibly even in contradiction with, some of its originalist methodologies, or at least some of the originalist methodologies that we see articulated by, at least some of the time, a majority of the justices. Second big thing that I noticed in the oral arguments, this picks up on a lot of what Ganesh was just saying, the minor importance, at least in these oral arguments, or perhaps even unimportance of the common carrier issue or related issues. I've been fascinated by common carriers. I teach property law. I've written a great deal on takings and the right to exclude and government, and so on and so forth, and the limits of the government's ability to, in effect, regulate or change rights to exclude without giving rise to regulatory takings claims. It's a fascinating and now dynamic area. So I was watching this with particular interest, but I had never been convinced that it mattered much whether or not any of these entities count as common carriers. It may matter a little bit on the margin, but in terms of the big picture, are they like common carriers, Facebook, et cetera, or are they more like just some kind of ordinary business? It's really hard for us, I think, to analogize. I don't disagree with anything that Ganesh has written radically. I'd say we see eye to eye on a lot, but at the same time, and these don't look a lot like the traditional common carriers. And so would it be, it's not that we can take any kind of a doctrine that has been developed in relation to these older common carriers and apply it, in effect, in an easy, clean way to these new entities. Now, one question that lurked in the Texas case with respect to the Texas statute is a perennial tough question. What are the limits, if any, of states to designate which firms are and are not common carriers? There's very little authority on this. And so when I first read the Texas law, I thought, maybe if the litigation develops in a particular way, we're actually going to have some information on these, on the ability of states to do this or not. I'm skeptical about that again, because I'm just not so sure that it matters. And of course, it's not the kind of thing that the courts would necessarily want to wade in on unless they had to, because the designation of a common carrier could lead to a reduction in rights to exclude. And that, at least when we think about recent takings cases the Supreme Court has handed down, in particular the Cedar Point Nursery case, that could open up claims that the designation of a firm as a common carrier in effect has affected some kind of taking for which just compensation is now warranted. And that is, so the bottom line with common carriers, it seemed to me, quite possibly coming out of yesterday's oral arguments, is that regardless of whether or not any of these firms count as common carriers, whatever definition of that term we might embrace, and regardless of which governmental entity has the power to so designate firms as common carriers, we're left with the fact that first, states exercising their police powers, there to, in effect, provide for the public good, for basic health and safety, do have very broad powers up to a point to regulate these firms. I differ with Zephyr in that I don't see this as a reclaiming of power. I think the state's strong police powers have been there all along when it comes particularly to imminent threats to health and safety. And second, that the First Amendment rights of firms are certainly not lost if they are common carriers. No one, I think, has ever argued to the contrary. But the question is going to be just how broad those rights are, which brings me to my third point, which is the breathtakingly broad conceptions of expressive conduct articulated by NetChoice. I just was gobsmacked that we had moved from a situation where there was a question about whether or not these firms were engaged in speech at all. One could certainly argue, one could certainly continue to argue, no, this isn't speech. They're careful curation, as they spin it, of various of content. It's all conduct. But NetChoice, of course, was having absolutely none of this. And this to me was especially interesting in the wake of the 303 Creative decision handed down by the Supreme Court. Justice Gorsuch's opinion for the court is, I think, amenable to a number of readings, but to me anyway, probably the best reading is a fairly narrow one that recognizes free speech rights of certain kinds of creators, such as an individual running a small firm that creates wedding websites. But to take that and to, in effect, suggest that NetChoice and other firms, when they're engaged in curation, have these broad expressive conduct that the First Amendment, that guaranteed by the First Amendment. And of course, this line of argument is in tension with a lot of what has been argued in relation to Section 230 and why it is good policy for big tech to enjoy such immunities as they do from the possibly from the sorts of from defamation and other things as the result of the content that they host. Final point that I thought emerged from the oral arguments was the possible preview of the government's position in the Murphy case. One of the elephants in the room, I thought, yesterday during the hours and hours of oral argument was the fact that everyone knows that these statutes enacted by Texas and Florida were inspired in significant part by a perception that the social media platforms had joined with government, particularly the federal government, in order to stifle heterodox and conservative speech. And even if some of these efforts to stifle heterodox or conservative speech, suspected efforts, I guess I should say, even if they were not the result of government direction made in an aggressive and explicit manner, they could nevertheless be understood as firms trying to curry favor with big government. Now, as Zephyr and Ganesh and others, many others have written, this anxiety about the possible collusion, or maybe we should say partnership to sound a little more neutral, between powerful government and powerful firms, particularly large ones, has been with us since colonial times, was one of the impetuses for the American Revolution, was a source of great concern in the early modern period. We just think about the debates over the banks of the United States, for example, these so concerns about crony capitalism. And so I was waiting with the oral arguments while listening to the oral arguments yesterday, I was waiting for some kind of intimation about the ramifications of this grave concern for these particular statutes. And we didn't get very much, except that Solicitor General Preligar, in the argument over the Texas statute, laid down a very strong marker, saying that, yeah, if government actually coerces platforms and takes over editorial decision-making, well, then that can be deemed state action. But if the government does anything short of that, the suggestion being that if all that's happening here is that social media companies are maybe just doing stuff that they know the government's going to like, well, that doesn't even come close to state action. Now, I think the challenges of defining state action have dogged constitutional law for our nation's entire history, have been especially acute in the last 60 years or so. So again, this is an issue that I've been paying close attention to, and it may well be that the Solicitor General's vision, at least as she articulated yesterday, will carry the day, and that it will turn out that state action is going to continue to have, or at least in most circumstances, will be granted a narrow meaning, as in the behavior of private firms will not be deemed state action unless there is some kind of smoking gun, some kind of strong evidence of actual coercion on the part of the government. But I am mildly skeptical on that front, and I would be very interested to hear others' thoughts. So with that, I will turn it over back to James.
Thank you. So I have a bunch of questions and some people are already putting them in, so I'll try to get as much as we can. And so let's just, with the answers, we'll try to keep it. Yeah. So the first question actually is right back to you, Professor Mahoney, and I'm going to try to weave in the two questions from Casey Maddox and anonymous attendee in this question. So, I mean, the basic point that I think Paul Clement was making and that NetChoice is making is, look, these are private businesses, they're private enterprises. They have no constitutional duties. The Constitution does not apply to them. They have no obligations other than whatever the free market will support, and they're speaking. And so why don't they clearly have a First Amendment right to say what they want and host whatever public speech they want? Casey points out, we have big cable news. Walter Cronkite for a long time was able to kind of spout the orthodoxy of whatever his news station. And then there's a fear, of course, that's sort of, I think, related to that, which is that if they don't have broad First Amendment rights, then the government's going to be able to push them to say whatever they want. At the same time, anyone who lived through the COVID pandemic, which is to say all of us, saw an extraordinary suppression of true, at least debatably true speech and an extraordinary manipulation by these private organizations of the public discourse. And I won't even get into the Hunter Biden laptop stuff before the election because, I don't want to be too political. But Professor Mahoney, what do you think about that First Amendment, just sort of baseline point that these are speakers, they're no different from, whatever, CNN, and it's up to them who they put on the CNN panel in CNN, and it's up to Twitter who they put on Twitter or whatever?
Well, I'd start just sticking with the state governments, with the fact that states do have robust police powers, and they have had these powers throughout our entire nation's history to guarantee basic public health and safety. Does that mean that they can make us all shut up? Of course not. But it also means that there are real problems that states have to address. The issue of children comes up again and again because children deserve special protection from the state. Not that we don't have a lot of respect for parental rights, of course we do, but one key job of state governments is, again, providing for basic health and safety. And that means paying a lot of attention to what might actually hurt children. So the idea that because they are private entities, they somehow enjoy some kind of untrammeled rights and the government can't regulate in sensible, carefully crafted ways is, to me, just ridiculous. Of course, the government can regulate up to a point. Now, I am probably more libertarian than others on this panel. And I would probably recognize more rights to economic liberty than others on this panel. I get all that. But one thing that I thought was striking about yesterday's oral arguments was how much the justices were in the middle, how much they were under, there seemed to be a sense in the room that there are a number of problems that state governments are going to be called upon to regulate concerning that are raised by this brave new world we find ourselves in. And it's not going to be easy. One reason that I suspect that there's an excellent chance that we will see a vacating and remanding or some similar disposition is that there needs to be more of the court may well welcome having more of a record.
Yeah, so maybe Zephyr, I could ask you then, I listened to the arguments, and I thought one of the interesting dynamics in this case is you've got the sort of three liberals who all seem to be in kind of different places, on the court. And I would think that Justices Kagan, Sotomayor, and Jackson would all have, I think Sotomayor and Kagan did dissent in Citizens United, and I'm sure Justice Jackson would have dissented as well. I mean, these are not, none of them are ones that I would normally associate with these sort of sweeping grand First Amendment arguments. And yet, again, I don't know what they're going to do, but Justice Jackson seemed the most sort of in favor of the states, and Justices Sotomayor and Kagan maybe less so. And, I look, on one hand, it's sort of like the Trump case. They've kicked Trump off Twitter. I think all of us can see that this is about far more than what happens with Trump and Twitter. And so I was just curious for your take on, the whole argument certainly, but in particular on the three justices that are more associated with kind of non-originalist legal thinking and such.
Sure. I did actually, I was there for the first 3 hours, but then had to leave. I didn't understand.
It's a marathon.
I didn't quite understand that this was going to go on so long. And unfortunately, in 4.5 hours, they couldn't even begin to cover the issues in this case. So I, like Professor Mahoney, was really struck and frankly very encouraged by, among others, but I'd say in particular, Justice Jackson really pushing on the implications that we don't know, the procedural posture of this case, really in some ways clarifying what is unclear. And I share when I first heard about this case, my own sense is that it was also the wrong time for this court to take this case, that an as-applied challenge would be far more appropriate. This relates to the 4.5 hours because the number of features of each individual bill, and the bills are extremely different, the ways in which those would apply, and to the question in the box, the very legitimate fears about inappropriate application of these laws are best dealt with in an as-applied challenge, not in the facial challenge context. And I thought there was real signals that Jackson at least was open to that. I wasn't present for the most of the argument on the Texas law, but I did hear, I believe that Kagan, and I think somebody else brought up questions about how this relates to public accommodations law. And although Kagan at first sounded extremely skeptical of the state's argument, there was at least some suggestion that she was also thinking through the way in which it might impact other public accommodations laws. And I want to be clear that I agree with Julia that and one of the things we highlighted in our brief is that there is a broad array, of laws that could be styled as non-discrimination laws that share some similarities to these laws, although they're quite distinct. And that they are part of state power. I'll just use one example because it may not be top of mind in the SEC context. If you want to, file a proxy statement, the company can't say we don't agree with this perspective, and therefore you can't file this proxy statement. That's a wholly private company in a wholly private context. Corporate regulation has a non-discrimination rule sort of embedded in that, just as one small example of the many kinds of examples. And of course, public accommodation laws are another set of those. I'm not a tea leaf reader or a court watcher, so I don't, and I'm not always impressed with those who are. So I'm not going to make huge, broad statements about which way they're going to go. I do think there was some misunderstanding of the Pruneyard precedent and what it means. And I believe that was from Justice Kagan. You know, there was sort of a sense that that's not relevant because that is, you know, this private company doesn't, the mall owner didn't have any expressive views, you know, that claim. Well, that's not clear at all. In fact, the mall owner had a view that the mall owner in Pruneyard, and I'm assuming some familiarity, but those who don't know, go read our brief. There is that's important. I'm going to spend just a minute on it, excuse me. At the heart of NetChoice's case is an argument by analogy to an early 70s case, Miami Herald. That's the heart. And they say, we are like the newspaper. And in that case, there was a state law that required newspapers to publish replies when the newspaper said nasty things about politicians. The court said, no, you can't do that to a newspaper. And a few years later, a mall owner said, I am just like that newspaper. Right? You can't make me have pamphleters here that I don't want to have, just like that newspaper couldn't. And the reason that Pruneyard is so important, that's the mall case, is because it cabined and limited Miami Herald and made clear that Miami Herald was not supposed to be a rule that undermined all of these kinds of general state exercises of regulatory power, including regulatory power to open up spaces by having non-viewpoint discrimination rules, and said, no, that's unique in a bunch of ways. And instead, there's a rule in Pruneyard that if a business, commercial enterprise, holds itself out as open to all, then the state can impose these kinds of, whether you want to call them common carriage, or, you know, you don't think of malls in common carriage, but non-discrimination obligations upon it. And by definition, anytime somebody's objecting, they do have they're claiming the expressive interest. So last thing I'll say about this is that I think it was Gorsuch who really got to the circular nature of some of the arguments. He was doing it in the context of talking about telegraphs, pointing out that telegraph companies wanted to and did try to push their own view, and a non-discrimination obligation was put upon them, and we accept that. That the example that is my favorite is voice over IP, currently not treated as a phone service with the common carriage requirements generally, but basically we treat it like the phone, right? Modern voice over IP has the capacity to edit what we're saying in real time or shut people off. But just because they have the capacity, and AT&T may desire to use that technology to shut down voices or amplify voices, doesn't mean to me that we can't have common carriage rules. So by definition, I'm sorry, James, I know I'm going on.
Go ahead.
But I hope that the court, all of the justices, really struggle with that, because whether you put them in the box of non-discrimination laws or common carriage laws or this form of state regulation, and state regulation that itself does not embody a viewpoint, that is a general power of states, and it's an essential anti-monopoly tool and consumer protection tool.
That's actually a good transition to a question I wanted to ask Ganesh. So, it seems to me that one of the problems with the way that NetChoice framed this as a facial challenge to the whole law rather than some sort of particularized thing is we ended up conflating a lot of stuff. So, the news feed, which is sort of the Facebook or Twitter generated feed, got conflated with direct messaging and then even got conflated with Uber or Etsy. And it seemed like, at least at some times, NetChoice was arguing that Uber and Etsy have the right to exclude Republican writers, even libertarian writers, the disabled, etc., which just seems like madness to say that Uber picking you up is an expressive activity. And so I'm just wondering, when we think about common carriage and all the different things these platforms do, how do we kind of untangle that? I mean, is the news feed the same thing as the Uber driver, or what do you think about that? You're on mute, so yeah, there you go.
It's a good question, and actually, in some ways, was the thing that struck me the most about the argument. And I think, like Zephyr, I made it through about 2.5 or 3 hours, and then had other things on my calendar. But what struck me is, in some ways, just how disappointing our conversation about regulating big tech is. And you saw it yesterday where, as you pointed out, there's all these distinctions that are being just collapsed because of how the posture of the case comes up, but where at times it was also unclear if people, the justices, maybe also the advocates, actually understood some of the core distinctions between these technologies. The second kind of challenge, I think, here, which to me is really the core of this, is a kind of conflation of companies with business lines. To go back to that example I talked about earlier, the judge, in the 1870s, 1880s, looking at the telephone and the common and the carriage company, didn't think that this was just, well, one company and we can't distinguish between telephones and carriages. The telephone business is a distinct line of business. The carriage business is a distinct line of business. The fact that they're owned by the same corporate conglomerate, or that conglomerate could have owned 100 other businesses, doesn't mean we can't make distinctions between these different things. And I think that's been a real challenge that you heard yesterday in the arguments. And so to me, a core part of this is distinguishing between one-to-one communications. When you think about the telegraph, the telephone in its core sense, though there are some boundary cases there too, the post office. I mean, there's lots of places where one-to-one communication. And that's different from one-to-many communications, which you can think of as the kind of traditional radio or broadcasting system where one person is allowed to reach a lot of different people in the audience. Those things are different from transportation. They're different from business-to-business enterprises. So, in the Etsy context, we got a lot of discussion about what does it mean for buyers and sellers on an e-commerce marketplace. We could talk about e-commerce marketplaces and we could talk about Etsy, Amazon Marketplace, but there are other analogies for that, which is, the fair, which was regulated according to some set of these NPU kind of non-discrimination rules, even in the Middle Ages. And so there's a separate set of rules for exchanges, fairs, marketplaces that are similar to these other rules, but designed to deal with the fact that these are business-to-business enterprises that are a platform for commerce. And so I think, to your point and to Zephyr's point, the posture of this case as a facial challenge made this hard to disentangle these things. I think it's critical to disentangle these because actually the nature of how you would apply a common carrier set of rules, which isn't just one rule, it's a set of different rules. And the way those would apply is going to be different if what we're talking about is one-to-one versus one-to-many versus transportation. And there are different issues at stake in each of those. You think about the transportation context, the First Amendment kinds of values we care about just are weaker, if not non-existent to some extent, at least in transportation. It's a different situation than a core communications platform, communications technology. And we should recognize those differences as we think about what the rules should be in this context, whether the way those rules are made is through a state statute, a federal statute, or the common law by judges. And so this, to me, I think was a quite disappointing feature of how this case has come up and the overall conversation and debate about it, because I think a lot more precision would be very helpful, and it would allow for analogies that actually make sense. And, at least in the part of the argument that I heard, it was disappointing to not see A lot of the other analogies, in the 1980s, there was a big debate about what was called dial-a-porn, which was telephone based pornographic recordings, which had in some level a one-to-one component, in some areas had a kind of a multi one-to-many kind of radio-like kind of component. And there was a lot of debate over this because Congress tried to regulate it. There were multiple court cases. It went back and forth. There's a lot of other analogies here that could be applied, but we can't really have a serious conversation about that unless we're looking at particular business lines and distinguishing between them, rather than just saying, well, the company is the entity. In some ways, I don't think that makes sense. You heard yesterday also discussions of cloud provision. That's an entirely different kind of business too. And it raises a bunch of different questions also than e-commerce marketplaces, social media, search. And I think we need to distinguish between these things to have a useful conversation about what regulation looks like.
Thank you. So Ryan, let me ask you something that I think is much more at the heart of what the tech companies would say is their First Amendment right. So, and it's a consumer protection question, which you'll know something about, I think. So we're all familiar, I think, with the addictive, almost compulsive nature of social media. And so I have two small children. Some of the justices, Justice Barrett has small children. I wonder if she thinks about this kind of thing. I am very concerned about all the indications that the tech companies have invested immense resources and leveraged data, the access to which no company has ever had in world history, into developing algorithms that addict children and push them into destructive behavior because that makes them look at it longer. And some of them commit suicide. The rest of them are still looking at the thing. Or for TikTok, there's plenty of evidence that it's pushing basically Chinese Communist Party propaganda on children, on young adults, on people. That strikes me as a major public health issue and a major national security issue. Do you understand NetChoice's position to be that they have a uninfringible First Amendment right to just do all of that, and the states can't stop them, Congress can't stop them, and we're just captive to whatever they want to develop in their algorithm, or kind of how should we think about that?
Yeah, that's a really good question, James. And I want to take a step back for a moment to try to answer that question well and point back to something that Ganesh just said, and also Professor Teachout said, which is that the posture of this case made it very difficult to argue and also very difficult to listen to, because it was a facial challenge. And underneath the hood of that facial challenge, you had two laws that had a number of different requirements and provisions, some of which were speech related, some of which were not. And then below that, you had entities, multiple entities who are members of NetChoice, who do a number of different things. I mean, these internet companies are conglomerates that provide multiple business lines. They're very large institutions that would be covered broadly by these very broad statutes. So you were trying to mix and match various applications of these broad laws to broad businesses. And I think what that created was a lack of ready analogies, or a shifting set of analogies. And it forced the advocates and the judges to shift analogies rapidly between applications. And you never really got to ground on how the law should apply. And I think what that caused was you saw some very odd arguments being made on both sides, that, and just looking at it as someone who's a First Amendment lawyer, and I want to be clear, I mean, you have a collision between two giant institutions, power centers in our society, that are going at each other in this case. You have government on one hand, you have large tech companies on the other. And there's a boundary war taking place in this case right now, and you're trying to mediate that through the lens of the First Amendment. It's very difficult to do on a facial challenge. And one of the moments that I noticed that I thought was just tremendous was at the very end of the Texas argument. The Solicitor General, Aaron Nielsen, had to be asked by one of the justices, so are you making the argument that common carriers lack any First Amendment rights whatsoever, even if they are indeed engaging in speech? Because it seemed that the argument being made by Texas to some extent would have stripped common carriers of all their First Amendment rights, setting aside the debates about Citizens United entirely. I mean, you've got this argument that seemed to go to a very strong, very big extreme. And I mean, we would certainly at ADF would yield to no one in our defense of the First Amendment. And when you have boundary wars between government and private businesses, or government and private individuals, the First Amendment puts a thumb on the scale and says who wins. It's always going to be private individuals who cannot be compelled or stifled by the government unless there's some strong reason for doing so. Now, when you have collusion between the government and these platforms, that changes the calculus entirely. And I think with Murthy and with Vullo coming up later in this term, we're going to see a very different set of arguments, and again, a shifting set of analogies there. But to get to your point, something that I thought was very interesting toward the middle of the argument, Paul Clement was asked by one of the justices, do you think it would be permissible, is it expressive conduct on part of the platforms, to exclude someone from the platform based entirely on off-platform conduct, based entirely on their identity, based entirely on something they said off-platform? And he said, absolutely, that's part of our expressive conduct. Now, I thought it was an interesting moment, because in 303 Creative, as you pointed out, as Professor Teachout pointed out, that was a much narrower application. There, we, on behalf of our client, Lori Smith, expressly disclaimed any intent to exclude services to anyone based on that person's identity. Our mantra in that case was, we serve everyone, we just won't speak every message. And that position taken by Paul in his argument was a little bit at odds with the way we argued 303 Creative. So I think that just gets to this problem that you have multiple different applications, multiple different regulations at issue, and multiple different service lines coming into play. Now, to your question, what do you do about this problem where you might have algorithmic sorting happening with respect to content that's driving content toward children? That obviously wasn't at issue in the case, but you can see this issue coming down the line. There are cases right now where NetChoice is challenging state laws that are trying to engage in protection of children. Again, the question has to always be asked, are you regulating the speech of these platforms? Because I think there's a good argument to be made that there's a consumer protection angle to be taken, and there could be appropriate legislation crafted to prohibit these platforms from targeting children in a non-speech way that would harm them, that would push content toward them in a way that would positively harm them. It is a public health issue. I believe it is a public health issue. And that's why I think this case is so difficult, because it involves a collision of two institutions, powerful institutions with different agendas, but ultimately we're having to mediate this through the lens of the First Amendment in a way that is completely unclear. And that is the problem with this argument. It's completely unclear how those applications would work, because this was all raised on a facial challenge through a PI posture in a very hurried way. So I do think there are opportunities to have robust conversations around how to regulate these platforms in the future to prevent them from targeting and harming children. But I don't think that issue was clarified from the argument yesterday because of this morass of applications that just kept revolving around the argument.
Thanks. So I have another one that I kind of want to get everyone's reaction to, if possible. So one of the things, and I'll start with Julie, we'll just go to the same order because that's easier. But so one of the things I also thought was striking about the argument is, NetChoice's position is based on the First Amendment. And obviously the US Constitution is sort of the neutron bomb of American law, right? If the First Amendment protects all of this behavior, then nobody can ever regulate it. We're never going to actually know what any of the regulations would do. And all of it's just going to get stopped right at the front gate based on what strike me as basically predictions, and in this case, predictions without even any underlying evidence about what these different regulatory measures were going to do. So, for example, one of the people in our Q&A pointed out that when the fairness doctrine went away, maybe you had a greater profusion of views. I haven't looked at the empirical evidence of that, but it just seems to me that it's not as though letting Texas and Florida or California or New York experiment with different policies. That is a much less dramatic step than having the First Amendment just come in and say, no, the tech companies can do whatever they want. We're done here. And I'm just curious, we'll go Julia, Zephyr, Ganesh, Brian, what do you think about that? And whether, part of the problem here is that we've just rushed into court with the broadest possible theory before we've had any experimentation at all with policymaking.
Yes, I think that the facial challenge aspect caused a great deal of mischief, as we've been discussing. But I also think that the hasty drafting of the laws is a problem. The Florida law in particular contains a number of provisions which remind me of a First Amendment course exam issue spotter. You can find a constitutional problem in just about every paragraph. And so that may, of course, have led NetChoice and others to think that they had an easy layup here. Look at what these people in Florida have come up with. I bet we can bring a facial challenge and get this one, kind of done away with immediately. Now, it would be very entertaining if I could tell you that I think the Florida legislature actually lured them into a trap by making them think they had an easy facial challenge, but then they get to the court and it doesn't work that way. I doubt that's actually true. But this does raise to me the possibility that perhaps legislatures, including those of Florida and Texas, might want to think carefully, listen to the oral argument, read the briefs, a number of excellent briefs filed in this case, and think about revising these laws other legislators too, I hope, are now crafting regulations that are just a lot more careful and a lot more thoughtful.
Zephyr, what do you think?
I think your question is absolutely essential. So, Julia's right that they did end up talking a lot of sort of like, what have we stumbled into, about the within statute implications. They started to sort of realize, but of the many things missing in this conversation, which is the thing that I frankly care the most about, was the implications outside of these statutes. And there was virtually no conversation about that. I think Justice Gorsuch asked a few questions along these lines, but it was not fully explored. And I frankly think it is the most important because the need for states and the federal government to experiment to see what impacts are is profound. Now, I do think those should be within limits. I don't think the states should be telling the platforms the viewpoints they can and can't have. But in as much as the laws themselves are neutral, that we should err on the side of, and that I hope the court errs on the side of caution. In some ways, this is an institutional question with a bunch of institutions that a lot of us are unhappy with, right? Which institution is best suited to draft regulations that will be flawed? By the way, they will be flawed regulations. I don't imagine that we're going to get it, that there is a right, that it's right here. I have some ideas. I think they would need to be tried out. I think they should be neutral, right? But they won't all work in all the ways that we want them to. But that to encourage states to allow them to experiment. So I really think that, to me, the big question is, if it doesn't go back, and I counted 4, again, I'm not a watcher, but I counted 4 for a full, remand, go away until you have as applied. That suggests that some other justices actually want to, Coney Barrett, possibly Kagan, wanted to make a broad statement about platforms having First Amendment rights, applying strict scrutiny as applied to content moderation. I'm worried about that for the reasons I said, because James, right now, and people probably don't know this, but under a 2010 precedent, Brown, regulation of children will be measured through strict scrutiny. So that standard, strict scrutiny, would apply to laws designed to limit algorithmic, addictive feeds for kids. Now, to your question, I think we should be allowing, as an institutional matter, New York and California, Massachusetts and Minnesota, and if that means, but even at the cost of laws that I really don't like, and I was clear in my brief and clear in writing about it, that I think that these laws are problematic and really sloppily written. They have some problems on their own, but they're also, as Professor Mahoney was saying, sloppily written. I just hope we err on the side of as applied, narrow, as opposed to broad claims that could end up really hurting child safety and other regulations.
Professor Sitaraman, what do you think?
So I'll just make 3 points. One is to agree with both Julia and Zephyr about not loving the laws particularly, and thinking that they were not really well drafted. I think, put aside the constitutional law school exam questions, just as a policy matter, I think if you were thinking very carefully about how to regulate tech platforms, and you wanted to accomplish the goals that presumably the legislature in both of these states had, there are better ways you could have gone about doing that would create a better statute. And I think that's, and again, as I mentioned earlier, kind of one of the disappointing parts about this, about where we are in this field of on the policy side of how do you regulate tech companies. The second point is, there's another part that we haven't talked about in which, much ink has been spilt, which is Section 230. And I think that's an important component here. And if you're talking about kind of experimentation and different ways in which the law develops over time, I think we can't ignore that as part of the story. And then the third thing that I think is important as we think about states, when you look back at how regulation happened in a lot of these other platform utility-like sectors, it started with the common law. It moved then to state legislatures, and then it moved to the federal system. And part of the reason it moved from the common law to state legislatures is a whole bunch of reasons why the common law isn't that great. You have to do things on a case-by-case basis. All the harms already happen before then some judge comes in and addresses them. By the way, it's some random judge coming up with it who may not be terribly expert in the issue, and there's no real democratic accountability to that. And then there are some real downsides to how states do this too, even though there are upsides, which is maybe there are interstate issues. Maybe you want rules that are similar across multiple jurisdictions. But one of the upsides to that approach, where there was common law rules, there were state legislative actions, and then ultimately federal action, is you actually learned a lot in the process, because you could see things and you could think about what the different rules are. And so I think one of the other pieces here is, we would learn a lot about this as we have. You think, I think there have been some studies, for example, after the European GDPR, the data protection regulation, and when you see the pop-up like, do you want this personalization of your data usage or not, right? Because of GDPR, you have those rules, and there are studies looking at that, and behaviorally, most people click OK and just move on, right? So there are defaults, there are other things that we learn. Did that really work? Did it not? We can have an assessment of that. But jurisdictions doing different things allow us to have that regulatory learning, which you don't really get when you have, as you started us out with, James, in this question, a kind of rule, and whether that's statutory or constitutional, that is the kind of across the board single, we're foreclosing every kind of possibility. I think that makes regulatory policy also difficult.
And then Ryan, I'll give you the last word, because I think we only have a couple minutes left.
We're running low on time. Yeah, I mean, I really don't trust the tech platforms and their content moderation policies. I really don't trust the government to tell the tech platforms how to do content moderation. So where does that leave us, right? We have two different institutions colliding here, both of them claiming a mandate to govern this important aspect of our economy, which is the moderation of online content. I think the First Amendment sort of breaks tie there. Obviously, the government is bound by the First Amendment, private actors are not. Now, the problem, though, and this gets to your question, James, which is this litigation somehow foreclosing a necessary iterative conversation around this important question of how do tech platforms and government and the public good interrelate? I worry that it could, and I hope that it doesn't. And here's what I mean by that. And again, I believe I would be very worried if the court were to issue a hasty ruling that somehow undermined the principles laid down in 303 Creative and other cases like that prevent the government from compelling speech on the part of private actors. That would be an absolute loss for the First Amendment. I don't think it's going to happen. I'm also concerned, however, that we might take at face value this notion that's been propounded by some of these tech platforms that they're just regulation-free entities, that they have an absolute right to avoid any kind of interference by the government in their operations. And oftentimes I feel like they're waving Section 230 as a talisman, sort of a get-out-of-jail-free card, and saying, well, you really can't regulate anything that we do, regardless of whether it touches speech, because of Section 230, and you're over-interpreting and over-determining applications of the First Amendment. And that's where I think the fact that we have a melange of arguments that were thrown into the mix yesterday through this facial challenge was so troubling, because there are ways to regulate these tech platforms, to prevent them from abusing their power. And I think it's clear that in many cases, they are abusing their power. And we have to find ways through an iterative legislative and policy-making process to address that problem, but to do so in a way that honors the spirit and the letter of the First Amendment. And so that's a very tough problem. And it's not something that we can solve overnight. It's something we have to solve because I think we are in a new paradigm where you have these two sources of power that are oftentimes in conflict with each other, sometimes overlapping and working in tandem with each other. It's a complicated situation. And so we have to provide room for policymakers to get this right. And it's not going to happen, I think, in the context of a preliminary injunction brought on a facial challenge to two statutes that, as some have noted, were probably not drafted in the best way. I mean, they were drafted in good faith. And I know many of the actors who were involved in drafting them, and they were operating in good faith based on what knowledge they had. But we're at the very beginning of this long conversation. And I think this is an important opening to that conversation, but it can't be the end to that conversation.
Thank you. That's great. And I see Alita's back, so you have the floor returned. But you're on mute. There you go.
Yes. Thanks so much. On behalf of the Federalist Society, I want to thank our panelists, moderator, and our audience for our panelists and moderator for the benefit of their time and expertise, for our audience for asking some great questions, and for your interest really in, I think, an important in some important questions that go really to the heart of the Freedom of Thought project. We welcome listener feedback by email at info@fedsoc.org. Thanks so much again for all of you for joining us today. We are adjourned.